really excited. Oop, recording in progress. I'm really excited to see everyone, and I think this is going to be really engaging. As Diana mentioned, please feel free to either use the raise your hand feature or drop any additional questions you might have in the chat. But I just wanted to get started with little introductions. So Tahir, starting with you, why don't you just introduce yourself, talk about your current job, and then kind of include the following in your response: your area of general practice, like if you do labor and employment law, what you specifically focus on, and kind of a description of your career and how you got there.
Sure, no problem. Thanks, Emily. My name is Tahir Boykins. I am originally from New York, went to undergrad at St. John's University and then Brooklyn Law School. I currently now practice out in California. I live in Los Angeles. My practice is mainly a general litigator, a business litigator. I also do a substantial amount of labor and employment work also. And I do some investigations and work with our white collar group. So I'm currently at Steptoe & Johnson is the name of my firm. We're a top 10 investigations white collar practice in the country. And so while that's not my specific group, I assist with investigations, especially when they're employment related, and just really as a litigator assist with anything that comes through on that end. I would say my career path, I've gotten here kind of just by saying yes to all types of work. I'd say, started off as a commercial litigator, but stayed open to receiving employment work. And when I moved out to California, I stayed with my firm, but due to unique circumstances, employment became my main practice area as opposed to just litigation. I did that for a few years, and then I went back to being a litigator, but now I'm one of the few people at my firm with employment experience. And so I've been able to use that in a way that benefits me.
Awesome, thank you. Janelle, I'm sorry, am I saying your name correctly? I apologize.
Janelle.
Janelle, would you please go next?
Yeah, sure. So I'm Janelle Myers. I'm a fourth year at Weil Gotshal Manges in the bankruptcy and restructuring practice group. While I was at Emory Law School, I took a bankruptcy class and found it really interesting. And then when I joined the firm as a summer associate, I rotated through that practice group because it's one of our biggest groups, and ended up really liking it. So then I clerked for a bankruptcy judge in the Central District of California, and then started at the firm a few years later. My practice mostly focuses on company side work. So any companies that need to be, put in bankruptcy in Chapter 11. There is a side to this practice where we do creditor side representations, but I haven't quite done that yet. So I'm hoping that'll be like the next step in my career.
Awesome, thank you, Janelle. Gabriella.
Hi, everybody. My name is Gabriella, and I went to American University, Washington College of Law. And I am currently an associate at Hudson Cook. Hudson Cook is a financial services law firm. They do mainly compliance, but currently they're compliance and regulatory work, and currently are growing their litigation practice group as well. And I started out as a general litigator as well after law school, but wanted to focus more on financial services and kind of decrease, I guess, what litigation can amount to, and have a slower schedule, I guess, is kind of the reasoning behind it. So I transferred to Hudson Cook with my interest in financial services and focusing more on arbitrations and things like that.
Great, thank you. Michael, you're next on my screen, so You're up.
Sure. Hey, everybody. My name is Michael Buffardi. I'm a managing director at FTI Consulting. So I'm one of those people that has the alternate careers in the legal field. I started off as an attorney for the government. I initially worked at the Treasury Department and then moved over to the Securities and Exchange Commission. So like Gabriella, I work primarily in financial services on the compliance side, and I specialize in financial crimes, money laundering, terrorist financing, any threat finance is the term that people generally use in that field. I was a lawyer for a while, and I got so overly specialized that it made sense to jump over to be an independent consultant and an expert witness. Instead of competing with lawyers for business, I figured it'd be better to be a resource. So that was how I got to my job now.
Cool. Khalil.
Sure. Good night, all. My name is Khalil Nobles. I'm probably a tweener between the alternative career / traditional lawyer. I'm currently a senior associate at Wilson Sonsini Technology Transactions Group on the IT side. What that means in layman terms is M&A transaction. I work on the IP, such as copyright, trademark, patent side, as well as the commercial contracting side. I also have a standalone practice where I represent startups and mature companies and help them to monetize technology by way of contract. So joint ventures, strategic alliances, master services agreements, and everything few and far in between. I say alternative career because I started in-house at IBM first at law school. I never intended to ever go to a law firm. I thought it would be too strenuous on family, and watching TV. It seemed like a horrible place to be, and everyone would be super sharp elbowed. Yet 4 years later, I'm still at a law firm and can't see myself ever going back in-house. So I look forward to meeting everyone and learning more about everyone. And thanks all the students for showing up tonight.
Thanks so much, Khalil. While I'm on you, can you just kind of describe a typical day in the life for your practice? I know for some of you that's going to be it changes every day. And there is no typical day in the life, but to the extent there is, can you talk through that?
Yeah, sure. So a typical day probably, so right now I represent a mix of startup companies and mature companies. So for the mature companies, it might be, I get a call from a general counsel at big company X, hey, we want to get into crypto services, or we want to enter into this multi-year transaction with another company in our space. Can you meet with us to talk through what that would look like? And then I would probably jump from there to getting a call from a startup founder saying, hey, I want to use data in a way that probably I should not, but I want you to tell me why I should and should not anyway. So it's counseling startup founders through their use cases and how to use technology, more so data as part of their technology on an app deal. Then it's responding to any email from the corporate team regarding the transactions documents. It might be helping due diligence and managing the junior and mid-level associates. So if they find anything that could be deemed a red flag or a material business point that should be reviewed and then talked through with the client, they'll raise those with me. And if I'm on any investor financing, then it'll be talking to the investor about whether or not they should invest in a startup. So that might play out over the course of, I might wake up at about 6 a.m. I'm on the East Coast, so I'm up at about 6 a.m., try to get a Peloton or actual ride out done, take the kids to school, get back in front of the computer by about 8:30, start responding to emails, churn. I try to work in 90-minute sprints. So I'll try to, not answer email for 90 minutes at a time and just handle one task at a time. Doesn't really work, but that's what I try to do. And then by about 4:30, pick the kids up, taken to activities, and then get back on the computer at about 7 and sign off at about 11 or 12.
That sounds really familiar as a former M&A attorney. I did the opposite. I moved in-house and I can't imagine going back to private practice, but.
I totally understand.
Gabriella, how about a typical day in the life for you?
Well, like you said, there really isn't a typical day in a litigator's life, but generally with the firm, depending on what active cases we have going on, I'm a fourth-year associate at the firm, so I help any partners and senior associates with our active cases, which can lead to opening up a case, communicating with clients on questions that may have come up the prior day, researching or developing and creating pleadings or anything that needs to get filed, communicating with opposing counsel, all those types of tasks. On the admin side, I also have to balance my day with, drafting articles to stay relevant, any articles that might be important for our clients to know about, such as, new court rulings or new regulations that are coming out, and trying to, it's not legal writing, it's a very different type of writing, but it's trying to present those for our industry clients and things like that, so that they are aware of any developments in the industry.
Great, thank you. Tahir, what about you?
Sure. So, again, no day is the same. I think as a litigator, everything is cyclical. Every case is on some sort of cycle, and it really depends on where things are at the time. So, for example, right now I'm in the middle of discovery for a few cases. So between reviewing documents to determine if they're privileged, creating a privilege log, sending out subpoenas, drafting and sending out subpoenas. That's a lot of what I'm doing now. A couple of my cases are at that stage. As it progresses, you're drafting additional discovery responses to opposing counsel, to the opposing party, to gather information about them to support your case. Then there's, when typically if there's a dispute with discovery, you go into motion practice. Somebody's moving to compel or moving for protection against some type of discovery. If you get through discovery, you're now drafting motions about what, summary judgment, right? Rule in our favor. This doesn't need to go before a jury. We don't need a trial. Rule in our favor now. Those types of motions. In the middle of all that, there's always novel issues that come up. So we do a lot of researching, legal research on Westlaw, Lexis. Sometimes a good old Google search will help. I think that a lot of that is, most of what I'm doing in my litigation cases, my employment cases, I'm just typically, if they're not litigation cases, I'm negotiating contracts and severance agreements or employment agreements on behalf of my clients. Investigations, that's interviewing witnesses, reviewing documents, kind of organizing your thoughts and planning next steps, trying to think of the whole picture. At the end of an investigation, you need to give some sort of, decision you've come to, some finding. And so you're always thinking about that. Right now, I'm in a unique position because I guess I'll take a step back. When you are working at a large law firm, there are sometimes opportunities where you can work for a client directly, where we call it a secondment. So you'll be seconded to a client where you still get paid by the firm, you're still an employee of the firm, but you're contracted with the client and you only work for the client. You essentially act as their in-house counsel and you handle their internal matters. I'm in a weird position where I spend 50% of my time seconded and 50% still doing work of the firm. And, you know, depending on how much of that 50 is actually 50 or depends on the day. But it's in a unique position where I get to experience both the in-house world. So I'm one of our clients, I handle some of their employment matters. So we do some non-compete research, right? Or somebody's leaving to go to a new job, or they're coming in from an old job and they have some sort of restrictive covenants. They say you can't compete with us, you can't solicit X, Y, Z. So we review those agreements and we see whether they're in breach, whether we need to get approval to hire this person, or if they're leaving us, whether they're breaching our contract and we need to seek some assurances. So that's pretty interesting. Also running some investigations internally also. Yeah, and overall, I think what I've noticed more about being in-house is a lot of more meetings on my calendar, a lot of discussions and hearing other people, outside counsel tell me about what they've got going on, which is interesting, a different perspective. But when I'm working for Steptoe and not the client, I think it's more of more work as opposed to meetings, more active tasks as opposed to meetings. So that's a little bit of a difference of what I see. And then of course, you know, around 5, 6 o'clock, I don't really need to do anything with the client because nobody else is doing anything at that time. Whereas for Steptoe, you know, I'm working until, you know, my work is done for the day, until I'm hit a certain amount of hours and I have time, I can finish the rest tomorrow, or if I have a deadline, I need to do it today. Doesn't matter how many hours, you just got to get it done by the day. So, you know, it depends every day, and uniquely for me, it really depends on every day whether I'm spending my time with the firm or with this client.
Yeah, you're definitely right about the distinction between in-house and private practice. My private practice, I didn't have to set blocks of time just to get work done. In-house, I have to constantly block off my time so I can do the actual work I'm being asked to do on top of what seems like endless meetings. Let's see, my screen shifted around. So Michael, I don't think you've gone yet, have you?
No, not yet.
Perfect.
I'm in sort of an independent role, which is a little bit different than, you know, most traditional lawyers, which is, you know, representation of a client. I do have clients, but I tend to sit in the middle between a financial institution and the government. So financial institutions, banks, brokerage firms, you know, things like that are supposed to have compliance programs. My main specialty is anti-money laundering. So a lot of times clients will just, it's whether it's in writing, and there's different forms this can come into, whether it's an independent report or conference calls, emails. You know, I tend to get the question, can I do this or can't I? Am I allowed to do this? And it's a tough question, and I think a lot of good lawyers will tend to not see things as binary. So it's not very often where something is absolutely prohibited or absolutely allowed. So the more you can see things as being on a spectrum, I think that tends to make your life quite a bit easier. I mean, you'll learn in crim law when you're talking about outright crimes, you know, there are justifications for there are justifications for the government charging you with murder. There are justifications in the civil law sense for torts, you know, there are reasons, there are affirmative defenses for things. So, I mean, my job is a little bit less extreme than that. But, you know, just being able to surf that spectrum and being able to create an argument for wherever you can convince the client to be on the, you know, wherever they end up on, you know, based on what their risk appetite is for doing or not doing a thing, is being able to adequately explain that. Can you give a justification for this? Is it supportable? And then finding the legal support for that, or the, you know, the compliance support for that. That's a huge thing. So I basically stand as a referee between the government and the private sector, which can be interesting.
Sounds like it. Janelle, I think you're yes, Janelle, could you kind of talk about your, was it typical day in the life?
Yeah, so I would say for me, no 2 days are really the same. One day I could be on back-to-back calls between, clients or internally at the firm or with the financial advisors that we work with to prep a case. Or I could spend an entire day drafting various pleadings. There are days where I do both. As a fourth year, I'm also managing junior associates. So there will be times where I'll spend part of the day explaining an assignment, and then the other part of the day I'll be reviewing it and potentially redoing it if it isn't exactly what we were looking for. And then occasionally, I don't do this so much now that I'm more senior, but I did do a lot of research before. But I would say nowadays, most of my days are filled with client calls. One of the scary things about being a mid-level associate is that clients will just call and ask random questions, and I'm like, I guess I'm qualified now. And it's terrifying, but then you find that you actually know more than you think. And yeah, I would say there really isn't a day that's the same. It's all very, very different. The fun days are when most days are taken up by court and you don't really have to work that much, but then you kind of regret it later because you're up all night doing the stuff that you didn't really do in the daytime.
For sure. So we got an interesting question in the chat. What's the difference between transactional lifestyle and litigation lifestyle, in terms of workload, hours, benefits? Does anyone want to volunteer for the litigation portion? Janelle?
So my practice is actually both. We do a mix of transactional and litigation. So I can't speak to each really separately on a more fulsome basis, but I would say transactional work is more like deals. It's some litigators say that they fix the problems that the transactional lawyers created. At times that's true, but I litigation is more with being in court, drafting pleadings, getting in front of a judge, actually prosecuting. Transactional is more finding transactional, for lack of a better word, solutions to a client's problems. It can include M&A work. In the bankruptcy space, it's usually a lot of distressed M&A work. Usually hedge funds or private equity firms are buying a company that doesn't have a lot of liquidity or cash to pay its debts, and they're trying to help them out by offering to purchase. That's kind of how it takes its form in a bankruptcy setting, but I think others should speak to each in their own right.
I would add one thing to that in terms of lifestyle differences. When I talk to the litigators, they say, oh, well, we have set dates, we have firm deadlines in order to get things done, right? You might have to file a motion, and I might butcher this because I took Civ Pro as a 1L, and since then I haven't thought a lot about, motion practice. But you guys on the litigation side typically have actual court-imposed deadlines. You have to get a motion filed by this certain date for this certain judge a certain kind of way. And I think it's typically more adversarial versus on the transactional side. In theory, it should not be adversarial because both sides want the same things, which is to consummate the deal. On the corporate side, or transactional side rather, the other difference is most of the deadlines are imaginary, right? They'll say, oh, we want to sign by September 15th. Well, why? Oh, just because. Sometimes it might be that they have to announce earnings or something like that. But 9 times out of 10, the transactional deadlines are arbitrary and self-made, but that can also lead to, a lot more work on the weekends when you're getting close to finalizing an M&A transaction.
Yeah, I'll definitely second the deadlines are something I've noticed are different in speaking with my friends on the transactional side. But I think for us, you know, I always describe it to people as, you know, transactional is when, you know, you're trying to come to some sort of agreement, some deal, create some sort of relationship. And then litigation is typically when that deal or relationship goes sour. And then we step in and we either try to resolve it before it goes to act, you know, in the pre-litigation stage. What can we do here to prevent this from going further? Because nobody wants to pay litigation costs, lawyer fees for litigation, it's expensive. So we try to find some resolution that can't be found. Um, you know, now we're going into more adversarial territory, right? And you know, sometimes I have great opposing counsel where, you know, we can work together, and even if we're representing our clients, we can do so in a nice, cordial manner. But there are some where it's just like, you don't care for this to be friendly in any way, and you'd rather, you know, throw insults and be not uncooperative. And so I think that that can be a big difference in kind of, although I'm sure in transactional you deal with some uncooperative opposing counsel as well. But I think that, you know, deadlines are harder to move, right? If it's a court deadline, you need the judge to sign off on it, and getting approval for that is tough. If it and so typically when you know ahead of time, right? I can typically, my friends want to hang out next weekend, I can say, oh, I don't have anything due. I don't have a motion due Monday or Tuesday or Wednesday. Maybe I probably can come out this weekend. You can't fully predict it because sometimes there's emergency motions and things that come up. But I do think that overall you can kind of plan out, although you'll know you'll be busy, you can kind of carve out some time knowing where your deadlines are.
And I don't know if Khalil can speak to this as well, but when I was in private practice, I would say transactional work, at least historically, used to be a little bit more cyclical. It would get really busy right before summer, and then it would kind of be a little bit quieter, and then it would get really busy right before year end. Of course, if your clients have different fiscal year ends, they have different self-imposed deadlines that may or may not be real. But that was something else that was kind of different, I think, with my litigator colleagues. It's steady work all throughout the year. Another really interesting question that came up is, how did you know which area of law called to you the loudest? And did that change from what you felt you were first drawn to? Michael, I'd really like your input on this since you're completely out of that space now. But I think that this is a great question for everyone. So I will follow as my screen keeps changing, I'm going to try to keep into some sort of order.
Sure. I think I don't want to say, you know, what you originally think that you might want to go into might not end up being the thing that you practice, because, you know, people do, you know, have passions. They do have things that they have always known they wanted to work with, or areas they've always wanted to practice in, and just stick with that to the end. And I think that's incredibly important to have that level of commitment, so long as you continue to check in with yourself and say, like, oh, is there an opportunity that is here? Am I recognizing this opportunity, and am I okay with letting it go? Am I okay with making that choice? It's an ongoing, every day is going to be an ongoing choice of, do I want to do this? Do I still want to work at this place? Do I want to be a lawyer anymore? Just give yourself that capacity to say no, or to say, I don't want to do this anymore. And you never know what something is going to turn into. So taking that risk, if you are just not finding a satisfaction in something, or you think maybe you want to switch practice areas, I mean, go ahead and do it. There's especially, I mean, you're going to be lawyers. Like, there's very few things that you're going to be doing that are going to be useless to you or to a client after you've done them. You're going to be continuously building skills. And if you develop a secondary practice area, I mean, that's in this idea of cyclical nature of transactional work versus litigation. I mean, I've heard a lot of people say this: have two forms of practice, something when the economy is good and something when it's bad. So if you're a litigator and all of a sudden you start taking on bankruptcy work, you might not have had any desire to do bankruptcy work. And then now you could have a bankruptcy practice, and you may not want to do bankruptcy anymore, but the skill set that you learned by taking on that new practice could evolve into something else that you didn't even know was a thing. I didn't even know my job was a thing when I started law school. And it just sort of ended up this way. But just having that open mind and being able to say yes and no, and know that you're making a choice and be okay with it.
Great. Thank you, Michael. Gabriella, how about you?
Sure. That's a really great question. And I'll admit that I went or decided to go to law school because I thought I wanted to do immigration work. I'm originally from Bolivia. And so I was like, I'm going to go to law school. I'm going to do immigration work, and I'm going to help all these people here in the US. And, but I guess part of being a Latina is also you can get really emotional. And I think that, my internships with immigration firms just took an emotional toll on me. And so I was like, I don't know if I could do immigration work 24/7. So, but I still like the idea of helping people, problem solving, and, being able to argue important issues, whether it's in court or some other venue. And so that's why I continue to stay on the litigation track. And I found that, by being flexible and, as everyone has kind of talked about, saying yes to different types of work, when you're at a firm, you can do pro bono work. And so part of that, can be immigration work or whatever it is that you're passionate about. And so I have, handled different types of pro bono work with the Latino population here in DC, which has been great. And it's not, a huge part of my practice, but I've been able to, stay in touch with my community and work with them and deal with different kinds of issues. The other thing I will say is that a lot of times your practice can also involve some of your passion. I think in financial services, I've kind of started leaning towards language access in terms of, banks and their financial institutions and their compliance programs and what that means. So that's another way that I've tried to incorporate my background into my practice area as well. So don't be afraid of the change. I mean, there are different ways and avenues that you can find what you're passionate about and change, and be open to that.
I really like how you are also speaking to ways to make sure you have career fulfillment. I think that is something that a lot of attorneys can lose. You're just kind of going through like deal after deal or case after case. And it's important to find ways like participating in your firm's pro bono program that you can keep your cup full. Janelle, how about you?
So I got my undergraduate degree in theater, and one had no plans of going to law school. But when I got to law school, I thought I was going to be an entertainment lawyer or an intellectual property lawyer. And I quickly realized in learning more about each of those things that I did not want to be involved. And so during, I would say my 1L summer going through OCIs, I was very open to anything. And I think that helped me to get a lot of offers, but it wasn't until I went back my 2L fall that I realized that I wanted to do bankruptcy work, and just so happened to accept an offer from the firm with, the leading bankruptcy practice. So it all kind of just like happened, but I would, suggest that everyone stay open. You might go in thinking you know exactly what you want, but then you'll find out that you like something else a lot better. That's what happened to me.
Great, thank you. Tahir.
Sure. So I'm definitely one of those weirdos who knew in high school that I was going to be an attorney for some reason. I don't know why I thought it. I knew I I think my parents got in my head when I was younger about me always arguing and always telling long stories. But I then did mock trial rather in high school. And I was very fortunate enough to have an opportunity in high school to do it. And I loved it. And I thought I was going to be some big trial attorney, you know, the next Johnny Cochran or something, who knows. So, you know, it carried in the sense that I'm still a litigator, but I've never had a trial, 6 years in a practice. Don't go to court often, you know, argued a few motions, but you know, that's really the extent of it. I think that you know, I kind of realized that my career wasn't going in that direction when I started at a big law firm, when, you know, there's just less opportunities there. Typically, when you're working for larger law firms, they want, you know, the clients want the partners to go to court, to trial in court and things like that. And, you know, I had opportunities to try to, maybe I won't stay here. Maybe I live out my dream and go work for the government or something and get trial experience. And I think I just kind of kept an open mind to maybe I don't need to do trials to stay kind of happy with my job. I think, you know, obviously the deterrent of going government route is always, you know, the salary difference and such. And I think that paying off student loans kept me here. But I also think that I've found ways to get the most out of it. And like Gabriella said, through pro bono efforts, and really just taking the opportunity to pick your own cases. I started out my career almost never saying no, always saying yes to cases, to assignments, because I wanted people to know I was here to work and I wanted to learn different things. And then, you know, I stopped just saying yes to everything. And instead I started asking for things that I wanted. I started reaching out to people saying, I want to be on this case, or I want to work on a case in this area of law that you do. I'm interested in it. And I think that's kept me very engaged. I think keeping an open mind at first is important. I went my 1L summer, I worked in compliance at Prudential, and I absolutely hated it. You know, the dean of my law school was constantly saying, compliance is the future. They're hiring attorneys now. Like, this is going to be the next big thing. And I mean, I don't, he's not wrong, right? I mean, compliance never was a legal role, and now they're hiring lots of attorneys. There's a lot of opportunities there, but that was not for me. I hated it. And, you know, I was happy to have the opportunity to figure it out 1L summer before, you know, committing to a post-grad job or something. So I would just say, keep those opportunities in mind, especially now while you're interning. Try different things before you fully commit to a post-grad job.
For sure. Khalil.
I echo Ty here fully on the trying aspect of it. I wanted to be a patent litigator when I first went to law school. Thought to myself, you know, I have a science background and this would be my niche. And then after 1L year, I loved contracts, but I love CivPro as well. So I interned for an appellate judge, had a great time. I hated the kind of reading that I had to do. Interned for the Attorney General's office, and I thought to myself, wow, I'm interning for the Attorney General. But every time we won a case, you know, we were defending the Office of Temporary Disability and Assistance and the Department of Labor when they denied someone their unemployment benefits. So every time I wrote a good motion and the attorneys I worked for won, someone's mom or dad could not get so this is more like what I want to do. And then I interned at IBM and I said, oh, wow, this is more like what I want to do. So it was those opportunities, you know, trying a lot of things, a lot of internships that led me on the path to saying, well, I like being in-house. I like the client context. I don't necessarily want to be in court. I don't want to necessarily have an adversarial career. I'd rather be someone that is considered a strategic advisor or business partner who just happens to be a lawyer. And that's kind of what helped me pivot into the startup representation, where I can kind of help my clients understand how to monetize their technology, but still doing the M&A so that on the way out, I can protect the buyer and see where the issues are. And on the sell side, I can still say, hey, this buyer is being really aggressive, and they're asking about things that aren't necessarily that material based on the deal structure. So that helps a lot. Being that get on a call and say, hey, partner at firm X, why are you asking for that? And I wouldn't be able to do that now if I hadn't had those experiences of being in-house, being next to the business, and kind of understanding what matters in the deal and what doesn't matter. And I think Matthew said this as well, but it's like not being the binary yes, no person, but really being the it depends, or, here's your options kind of person. That all came from the numerous times I've interned in different places.
Great, thank you, Khalil. So we've had a couple of questions about imposter syndrome and how you deal with that during law school and for the first few years as an associate. Would love to hear, I think, from everyone on this. Do we have any volunteers?
Does that ever go away?
It never goes away. I'm still dealing with it.
I think that and the networking question, I think, is interesting, because those are two, I think, similar issues. This idea of networking and trying to put your best foot forward, trying to overcome that imposter syndrome, and also be yourself. I think, to me, those are related questions. Because whether you're networking, getting to know people at law schools, getting to know that imposter syndrome, everybody's really in the same position. If somebody doesn't have imposter syndrome, that's a real big red flag. I'm not a psychiatrist, but that's a huge red flag. And either they don't have imposter syndrome or they're acting like they don't have imposter syndrome. And that's really hard to develop empathy at that point. It's really hard to connect with people. So the more you are just yourself, like, the easier things are going to go. It sounds terrible to say this, but as a 1L, and as you advance through law school, you're going to be constantly surrounded by people who, to try as you might, you're not going to impress them. I mean, not for something that's inherently you, but it's just, they're around partners, they're around associates, they just want you to be you. Like, they don't want to be impressed by you. They want to get to know you. They want to know if they can work with you. They want to know if you are kind. They want to know if you are generous. They want to know if you care for other people. Like, those are the things that people tend to remember. And the more you try to impress them, it's just not going to come off that great, and it's going to seem like you're trying to be something you're not, and people are going to be like, ooh, I just want to know who you are as a person. And I think that's the, I don't know, for me, that's the biggest key. Is that the best way to develop empathy and learn about people and have people learn about you, and they're going to want to network with you more. And then 10 years later, they're going to want to work with you on a project when you're both attorneys at a law firm or one's in-house. Like, that stuff tends to last. So I don't know if that makes sense.
I think it makes a ton of sense. Janelle, did you have anything to add? You were unmuted for a moment, so I'm gonna jump on it.
I was just going to agree that it never really goes away, and you kind of have to remind yourself that you've worked really hard, and you're here because you just deserve to be, and other people believe in you, and so you should just try to believe in yourself as much as others do. I struggle with this every day. And just give yourself a little bit of grace when things don't quite go according to plan. Yeah.
For sure. Does anyone else to hear Gabriella, Khalil?
Yeah, I'll definitely add that, you're always going to feel like there's maybe more you can do, or you should have done, or that somebody's better than you, right? And maybe regret something in the past, but mistakes happen, right? Some of the best attorneys make mistakes. The best partners make mistakes. Some of them don't want to admit it, but they make mistakes. And at the end of the day, it's really just about reflecting on those mistakes and making yourself better. If you're constantly improving, then it makes it more difficult to doubt your abilities, right? To as long as you're doing your best and constantly improving, you're probably doing better than the next person. And so you just have to trust yourself in that regard. If it's something you really struggle with in a way that you feel is crippling, I mean, again, like Mike said, we are not psychiatrists, but seek a therapist. No, I mean that in a serious manner. Like we kind of dismiss it a lot, but I had a call with my therapist from 3 to 4, and now I'm here 4 to 5 talking to you guys, right? Like that stuff helps. It really does help, and I always recommend it because there are certain things that you won't be able to figure out on your own, and it helps to talk to somebody. Even if you don't go to therapy, talk to people, talk to the people around you, and get better and get some answers, because you're gonna doubt yourself. That's natural. It's just really what you do about it afterwards.
I'll echo that as well. I feel like imposter syndrome is one of those things where I worked in different organizations, different firms, and I think where I felt the most comfortable is in places where they kind of acknowledge that no one is perfect. As Tahir said, people do make mistakes. I have partners all the time who've been practicing 20, 25 years, and they'll send me something. And if I find, a typo in their form, they're like, thank you, that's great. As opposed to some other places would have been like, well, that must have just got there, right? Like they almost would have treated it as if it was something that I messed up on. And I think that what helped me in my career thus far was having great mentors, great sponsors in these organizations that would ask me, hey, what do you need to succeed here? Because I think once you get to law school and once you get through law school, I think there's like when you pass the bar and all those things, there's a certain amount of competency that you have to have in order to get to that point. But to succeed in law firms and at large organizations, it's more than competency. It's about understanding the cultural norms and having the support so that you can navigate them. I never forget being at an old place I worked at, and I'm thinking, hey, this deal's all over the place, but I got cool with the corporate team, and they were like, actually, we're all going golfing on Saturday. Did you get the email? And I said, yeah, let me check. There was no golfing email in my inbox, and I knew that. But, this junior associate was getting invited to go golfing with the partners, and he was also with the client. So he had more insights into what was happening, but that also changed his trajectory because his team was full of rainmakers. So he knew how to navigate, and he was golfing and he was doing the more social things that I had no idea was going on. I thought if I just do the best possible work and read things 25 times over and try to catch every single curly quotation and double space, if I try to do everything perfect, that's enough. And it's not. It's more, that likability factor. Do people view you as somebody that they would want to socialize with? But the imposter syndrome hurts that sometimes because you spend so much time focused on perfecting work, which, as people have said also, I don't know of anybody that does everything perfect every time. You might, out of 10 assignments, you might nail 6 or 7 of them. And that might even be, stretching it. That assumes you have enough time to do everything, right? So I think you have to have a balance of sponsors, mentors, and therapy definitely helps too. I definitely recommend that, but it's also having an understanding of how to navigate the organization and then having the sponsors and the mentors and the resources to help you navigate and then still applying all of that. So it's never ending. And all you can do is just, put your best foot forward by using every resource possible.
For sure. I definitely wanted to echo Khalil's point about those soft people skills. They are super critical. I was told when I came to my current job that by multiple people, unprompted, it doesn't matter how good of an attorney you are. If you're a jerk, you're not going to survive here. And so it's really critical to be humble, to work on those interpersonal skills. I'm a huge introvert by nature. So I'm not always seeking out people to have friendly little chats in the hallway, but it's really important to navigate the culture of wherever you are, whether it be a firm or a company, or you've started your own company, and really hone out on those soft skills. Gabriella, do you have anything you wanted to add?
I would just echo what everybody has said. And I guess from the law firm perspective, I think one of the ways that I try to push imposter syndrome away as hard as you can try. I try to, know more than the partner. So if I have a case, I want to know dates. I want to know who the parties are. I want to know what our deadlines are, because I never want to be in a position where, I'm asked a question in a meeting and I'm like, I don't know when the complaint was filed. So I think just kind of like preparing yourself way in advance for any type of meeting or things like that has really helped curb my nerves or any type of, questions that I may have about my abilities. But the other side of that is that when I'm receiving either critiques or criticisms for my mistakes, I try to not take those, you don't want to take them personally. It's can be hard, but because we've all worked so hard to be here. But I try to find resources where I can potentially, improve those. If it's a writing issue, I either, is there a CLE out there that the firm can help me with? Or does the firm have, some writing training that they can provide me with? Things like that you want to, and this goes all to your, own personal development and personal growth as an attorney. Being able to adapt and being able to see these different types of resources for you that are out there. Not everybody talks about them, and it takes a certain level of humility, I guess, to seek out these additional ways to help. But it is the practice of law. You're constantly learning. Just because you took legal writing in law school doesn't mean that you're the perfect writer and you'll never have to take a legal writing course again. So just small things like that help curb the nerves and the, I guess, questions. And to the genuineness point, I think that like sometimes when you're working with a partner that you've worked with a lot, or someone, your superior or a senior associate, I think it helps saying, I don't have the answer to that now. Can you give me a couple hours to research so I can give you a more developed answer, versus, trying to answer something because you're scared or worried of what they might think of you. I think it comes off more genuine and a lot better when you take the time to say, I don't really have the answer to that, but let me take a couple hours and I'll get back to you.
100%. I think we all of us on the panel have worked with those attorneys who kind of are known to shoot from the hip. And you kind of have to, you don't want to be known as that person. Let's put it that way. Well, I think we have time for just one more question. I know we're almost out of time. And Janelle, I was hoping if you're able, this is, I think, the most commonly asked question I've seen is journal versus moot court. Should they take both? How critical are they to get an internship? What are your feelings and your thoughts?
So I think if you want to do big law, it helps to have a journal on your resume. And I think most firms prefer like the main journal. But honestly, like my friends who have done moot court, they all get great jobs, even if, and I think someone asked, like, if you're not interested in litigation, does it still make sense to do moot court? And I think, yeah, like you get great skills speaking in front of people, being asked questions on the spot that you may or may not have prepped for. It's just a great skill set to have. I didn't do it personally. I was more of a journal junkie, and really enjoyed that experience, though I think most people end up not liking it. I think journal prepares you to, like, know how to use blue Blue Book and, you know, work with other people, work with people who are more senior to you. If you're on the executive board, or even if you become the editor in chief, the thing that I learned in that position was, you know, like managing deals. Like I draw on that experience for that, working with different parties, managing different needs, expectations, goals. And so I think either one will give you a great set of skills that you will gain regardless of, you know, what job you land. And I also have friends who didn't do either and work in big law firms. So I would say, you know, it's great to try out one, but if you don't get on one, or if you just don't want to do it, it doesn't mean that you're not going to have like a great career. It might make things a little trickier, but I feel like people land where they're supposed to typically.
For sure. Thanks, Janelle.
No problem.
Here, how about you?
Yeah, I mean, I did both. And as Janelle said, I absolutely hated journal. I do think though that it was a big factor in me landing my first job. I think that, you know, it's a resume booster, right? It got me the interview. I think that that's really what it served its best purpose for me. Yeah, I learned a little bit about blue booking, but I don't think it was anything I wouldn't have learned anyway. Moot court, on the other hand, was by far my favorite part about law school. A lot of time, a lot of work, but I felt like it was the most fun and the most rewarding, and made the most kind of lasting relationships. I know a lot of people asked about networking. I think that networking at this stage is developing relationships with the people around you. And that's where it starts right now. Obviously you want to talk to people who are practicing and such, but you start here at that level, your peers. And I think that moot court, we were able to build more bonds and do that. And yeah, the public speaking, going to competitions, meeting practicing attorneys there, being able to exchange info with them. I think that a lot of that was more beneficial. And I think that it taught me a lot more about, you know, now when I have to go to court or even go to court through Zoom, I feel comfortable talking to a judge, right? Because I did that to a certain extent with moot court. So I feel like that benefits me more in practice. But I think you should absolutely try out for both, or, you know, try it, right? And if you don't like it, you don't do it maybe, or maybe you just stick with it, right? It's not forever. But it's great for what it can do for you, whether it's just a resume booster or actual experience. I think you try it. And if you don't, you'll still be all right. You have connections, you can reach out to other people, and build and ask them what they've learned and pick people's brains. And that's also part of networking too. So you kind of, you know, you get a lot of that out of people who have done it if you choose not.
For sure. Yeah, I also did moot court, but I despised it because I don't like public speaking. But Khalil, how about you?
I also did moot court, and this is back when I thought I was going to be, you know, the next big patent litigator. But what I will say that I appreciated about it was some of the moot court judges I had to deal with were some of the best litigators in the country. So their intensity and asking me off the wall questions, and then also interning at an appellate court and watching how the judges would treat unprepared lawyers and even how they would treat prepared lawyers. It was very insightful because for me, it gave me an extra sense of I'm not scared to be in the room if things get tight, if you know folks get loud on a call, that doesn't rattle me. Even if someone directly challenges something that I say on a call, I feel like I go into calls very well prepared. So if I say something, I know I can stand on it. And I think because of that, that makes my life a lot easier. And I take that experience back to, you know, my time on moot court.
For sure. Gabriella, how about you?
So I did journal, and I love my experience. I wanted to, you know, continue my writing skills, things like that. I didn't really have an interest in moot court, even though I wanted to do litigation. But everyone I went to law school with and did moot court really enjoyed their experience. I think journal writing was great. As Janelle said, you get to work with different people. And if you do get to become, as part of the board of the journal, you get to, add, you managed or, you helped supervise the up and coming, students. And it's also a plus if you get published. So you have the opportunity to get published. So that's my opinion on journal.
Michael.
I didn't do either, so I don't have much to add here. Yeah, I was at the Treasury Department during the day, so I did law school at night, so I was a little strapped for time. But I mean, the one thing I did take away, and this is from working with a lot of other attorneys and first-year law students at the Treasury and the SEC, you're going to have so many opportunities to learn how to write, and you're going to have so many opportunities just through finals, through legal research and writing. Unless you're really passionate about journal, I think, like Khalil mentioned, just the idea of being up in front of people talking and having your points challenged, because that is going to happen all the time. People are not going to like the answers you give, the advice you give, and it's not just opposing counsel. It's going to be the client. It's going to be people that you work with who maybe have competing ideas about how to move forward on a case or move forward on an issue. Just being able to stand on your own reasoning, your own preparation, and that's just so hugely beneficial. So my completely unqualified answer, I guess, would be moot court.
Yeah, I guess to tack back on to my initial distaste for moot court, it was, to Michael and to Here's point, super helpful. And it made me, I think, a stronger attorney, even though I knew doing moot court, I didn't want to do litigation. I just wanted it for my resume, to be completely honest. So try different things. It's always good. I know we're out of time, and I know there are a lot more mentee questions that you guys sent in. So to the extent something wasn't answered, I think I can speak for all of us and speak up if I cannot, but feel free to email your questions. I'm sure someone is happy to respond to them. I'm happy to respond to them. Sorry, my dogs are yelling. But thank you guys so much. Diane, I don't know if you have any closing remarks.
Yes, thank you. I just want to thank Emily for moderating this wonderful panel, all the students for joining, and all of our P2P board members as well. I did notice there were a lot of 1L centric type questions. So I think, planning wise, I think it would make sense to have kind of a 1L touch base panel, kind of talking about moot court, all these things that, our panelists addressed. We could get into some more detail. So look for that hopefully in the coming months. And I will, if the panelists all agree, I will send around their emails to the group. So if you have any specific questions or want to follow up on something, you can go ahead and do that. And the recording should be made available in a few days or so.
Thanks, everyone.
Thank you so much, everyone.
Thanks, everyone.